Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. I am dropping things on my desk. Alright, this is a video that I have to remake. However, tragically, so I made this video and the privacy settings on my microphone decided that it would tell me it was recording audio, but that none of it would be retained, which is super exciting. And I did not change those settings, and I think it's very strange that they turned themselves on. And I think Bill Gates and Windows and Yeti microphones are my enemies now. However, this video is important, so we must remake it. Okay. Think of this video as how not to approach an employment attorney, or potentially the worst way to approach an employment attorney. It was a long one. I suspect it's not going to be as long because I don't remember everything I said, and you know how we do here. We don't really have scripts, so I was riffing, as they say. But that's okay. That's all right. It's fine. It's fine. My time's not valuable. Why would my time matter? Why would my microphone work? That would be too much to ask for. Okay. All right. We're getting a little dramatic here. Let's dial it back. All right. The single worst way to approach an employment attorney, I would rate as what I call the emotional outburst or the emotional leverage. These take a lot of different formats. I'll give you a couple of quick examples. The two that jump to mind immediately are, I've talked to 45 attorneys, and they have all turned me down, and you are my last hope. That is, we'll talk about that one at length as well. But the next example that I always think of that we actually get all the time, multiple times a year. I have been turned down by every attorney I have talked to. If you don't take my case, I'm going to kill myself. And I don't joke about suicidal ideation. It's not funny. The overwhelming majority of suicidal ideation and threats of suicide are tied to mental illness. And, we take them very seriously. So let's get into it. Let's talk about these two forms of approaching attorneys. What do they represent? An attempt to generate some kind of emotional leverage. You want your case to be taken. So you create, not you, some hypothetical person creates a narrative to develop what they view as a sympathetic story, and they try to leverage that. Hey, I need your help. This is why you have to help me. Now, on both of those scenarios, let's start off with what we know about employment attorneys. Generally speaking, employment attorneys are not the best human beings. And I say that for all of us, and myself included, right? We're conflict-oriented, narcissists, generalizing, not everybody. I met some lovely employment attorneys. Many of us are socially inept, not really in touch with our emotional side. We often don't feel the conflict we engage in every single day, because if we did feel the conflict like a normal human might feel and experience conflict, we wouldn't last, right? Caring, lovely, heartfelt employment attorneys often don't make it. They have short careers, right? And this is my opinion. All this is my opinion, right? But when you open with a gambit for emotional leverage with an employment attorney, I would argue that statistically speaking, you are going to get a response ranging from, I don't understand this emotional argument you're making, to, this doesn't matter to me, I just want to know if I can make money, to, oh God, not one of these again. God, I am so sick of these. and all these people trying to take advantage of me, right? These are the responses you get. Is that good? No. Well, I don't want to leave it out. There's also a response that you're going to have to deal with, which is a lot of times people are like, there's some, I think in our field, some discrimination towards mental health issues. So overly emotional clients, or clients who approach on a very emotional vector, will often receive perceived disability, discrimination, negativity, where employment attorneys will just say, oh, God, this person's not well, and then they won't want to represent that person because, there is a perception in our field that representing people dealing with mental illness will shorten your career and create a bunch of acrimony in your life, because people with mental health issues have a tough time, have an exacerbated, a worse than usual time getting through the employment litigation process, because the employment litigation process can be so fraught, and some folks with some mental health issues, and I'm describing the mistaken discriminatory thought process. I'm not giving this credence, but some folks with mental health issues have trouble regenerating their well-being fast enough to make it through the process, because well-being must be viewed as a slowly regenerating resource. The well-being of the plaintiff is a slowly regenerating resource in this industry, and you have to take care of the plaintiff and closely husband and protect. And I mean husband in the agricultural sense, like you husband the land, and not husband as in like husband, right? But you need to take care of their well-being. So that's an issue as well, because, and also listen, there's definitely a perception, and I have other videos talking about employment attorneys responding to people with bipolar condition and stuff like that. There's a perception that those mental health issues can create a lot of wear and tear on attorneys, staff, partners, everybody. And folks do want to avoid that, right? Like if you're out there being an employment attorney somewhere and you're doing great, you got the cases you need, and somebody with a claim, solid claim, approaches you, but they approach you in a really wild and perhaps really wild fashion that you might, for whatever reason, assume was tied to some kind of mental health issue. And you just look at it and you're like, oh, this person's going to scream at me every other week. That's how these attorneys get to this notion of, I don't want to represent people with mental health issues. It's one of the ways, right? But let's talk with some specificity about why these two forms of emotional leverage approaches are the worst of the worst. Let's recap. I talked to 45 attorneys, and they all turned me down. And you're the last one. You're my last hope. We call this the Obi-Wan Kenobi, which is like a scene from the original Star Wars where I think Princess Leia sends a hologram message to this space religious person called the Jedi, and they're like, "You're our only hope." And in the movie, Obi-Wan Kenobi's like, "I'm just gonna let the dark side kill me rather than deal with your bullshit because you're crazy." And I don't like using the term crazy, but you get what I mean. Maybe that's my own recollection of how that movie went. But that being said, the employment attorney response will not be positive to this kind of pitch. Let's think about what's going on here. I talked to 45 attorneys and they all turned me down. Cool, so not a case. We already know not a case, right? Or at least not a good case. Because in those 45 attorneys, listen, do I think that employment attorneys are terrible at listening to potential clients? I do. Do I think that they are terrible at valuing certain cases? And do I think that many employment attorneys only take easy cases? I do. Those are all failings of our industry. Do I think that 45 employment attorneys all failed you? I sure don't. Listen, it's a fraught industry. Many of us are less than what I would hope that we might be. But in 45 of the finest our nation has to offer, when it comes to employment attorneys, I assure you, someone listened. Someone listened. And I don't care if they listen because they're a good person, or if they listen because they're hungry to win cases and they want more cases, or they just need to make rent this month and they want to find a case that they can potentially win. But somebody out of that 45, probably I would think some 15 of the 45 might have listened. And they still turned your case down. That's meaningful. When you open with that, you're just saying, you're opening with, not a case. Not a case, or there's something wrong with me and people don't think they can get me over the finish line. That's what you're communicating. But let's take a little further. We can extrapolate something else. This person presented their case to 45 different employment attorneys and received 45 negative responses, some of which actually listened to this person. We presume. We believe. This person, this potential client, has no interest in the advice of attorneys. How do we know? Of the 45 attorneys she or he spoke with, it is my belief that at least 15 stopped to listen. So the 45 negatives, and a lot of the negatives are going to be like 5 minutes, 5-minute phone calls where they hear a quick blurb about the claim and they say, no thanks, at best, or get off the phone at worst, right? But let's assume, the full 45, you have about 15 people who listen for 20 minutes, half an hour. Many of those 15 would explain why the claim isn't viable. Like, I will often have a conversation with people. I'm like, hey, yeah, so this is how at-will employment works. You could be fired for any non-discriminatory reason or no reason at all. If you don't have a protected class, I have a limited ability to, leverage claim for you. And we have to really believe and have reason to believe that the protected class is why the bad thing happened to you. And here, you don't have a protected class. We don't have any evidence that a protected class is the reason why a bad thing happened to you. So that's why I'm not going to make you an offer of representation. And more often than not, going through that process will inspire folks and tell me to go fuck myself. And that's fair enough. That's the gig. If it was easy, everybody would do it. But, and it's also not fair to say more often than not. We'll say often instead of more often than not. So at least probably 15 of those people engaged in some version of that conversation with this potential. So we know this person cannot or is not interested in taking the advice of attorneys. Cool. So we have not a claim for somebody who's not going to listen to you during the litigation. It's about as bad as it gets. It's about as bad as it gets. It's hard to imagine it getting worse, right? But wait, it does. Let's add the second model of the emotional leverage approach to our scenario. Hey, I've been turned down by 45 attorneys, and you're my last hope. If you don't take my case, I'm going to kill myself. And again, people are going to think I'm making this up. This happens often. And also, for the attorneys, any attorneys watching, the correct response to that is a wellness check. You call in a wellness check to the local authorities, wherever they are. If you can ascertain that the person is not, how do I say this on YouTube without getting in trouble? Ascertain that the potential client is not a member of a protected class that might be at heightened risk from law enforcement. Like, wellness checks can be kind of a tense thing. And, sending law enforcement to do a wellness check on a protected class that has a great deal to fear from law enforcement is not ideal. I would argue in those scenarios, you're better off just letting them run the risk of speaking about suicide without some kind of intervention. And that's my assumption. That's my personal belief. But, if it's not someone who has additional reason to fear law enforcement, then yeah, we call them wellness checks. We get a lot of pretty straight up suicide threats in our practice, and the recourse is you have to do something. You have to be proactive, in our opinion. That does not make us friends. No one has ever been like, thanks for calling in a wellness check because I threatened to kill myself. That will never happen. But we're more able to live with ourselves. So, there's that. But let's take a look at this emotionally leveraged pitch. 45 attorneys turned me down. So still not a claim. I don't care. You're my last hope. I need to hire you on this case. Okay, you're not listening to attorneys. And if you don't take my case, I'm going to kill myself. Okay. So you've just activated all the mental health discrimination that exists in our field. Every single attorney in our field will hear that and either assume or wonder if you are dealing with a mental illness. And many of those people who assume or wonder will then not want to deal with you because you have a mental illness. Even if you have a good case, they will say, oh yeah, this is going to be horrible for me. This person's going to mistreat me horrifically, and I don't want to accommodate them. And if I just don't take the case, then I don't necessarily, no one will know that I'm essentially engaged in mental health discrimination. So I think this is wrong. To stress, this is wrong. This is the wrong thing to do. This is a giant failing of many people in our industry, but it goes on. It happens. So right off the bat, that's what's going on. Now, there's also some kind of tangible things going on here. Person threatening suicide while saying they want you to pour tens upon tens, if not hundreds of attorney hours and tens of thousands of dollars into a case for them. Guess what? If you're working on a case and your client dies, for any reason, the valuation of that case plummets and the risk in that case goes through the roof. One, we're certainly sad the person is now deceased. That is a tragedy, and that is hard on everyone involved. And you weren't one of the family or the friends or the loved ones of this person, but it's still hard. But on top of that, let's say you're 20 grand deep on this case. And you can't really settle because the person's deceased and, there might not be a trustee in place yet who can make those decisions. So you can't settle, so you got to try the case. Fair enough, cool, let's go do it. Don't take the case if you don't want to try the case. But now you got no witness. Your star witness is deceased. Think about the ask there. Hey, I need tens upon tens, if not hundreds of attorney hours and tens of thousands of dollars from you, and I think it's cool to run around saying I'm going to kill myself. So I'm just inspiring fear that I might not be around for the trial. I don't even think that's discrimination. That's just the attorney doing the math, right? Like, it's a concern. It's a concern. That's a real concern. What a horrible pitch to take a case. I don't like listening to attorneys. A bunch of people said I don't have a case, and I'm adding additional risk to your case on top of all that. Don't do that. I'm sure it sounds like a good idea. Like, it happens often enough that there must be something in human beings that we think that's a good idea to say that. Or maybe you grew up in a way where you could emotionally leverage people, or you grew up around people who cared about things like emotions, which are generally not going to be employment attorneys, right? I don't want people to kill themselves, but I also once had a defendant pretend to kill himself on the phone with me. He was an attorney, so he called me up directly, and he later called me and said, oh, I thought you'd be more upset. Nah, you're a bad dude. I mean, listen, I don't want anybody to be dead, but I'm not. I called the ambulance for you. I don't know what more do you. I'm not gonna. I called the ambulance. You convinced me that you'd shot yourself, so I called an ambulance. Then you called me back 20 minutes later and said, I thought you'd be more upset. You're a bad dude. You do bad things. I would not kill you. I would not cheer your death. But the extent to which I would warn you, yeah, listen, a lot of good people who die. How much mourning do I have in me? True story. Also, a really good example of how messed up employment attorneys are. Right? I mean, right? Perhaps I'm worse than average. I don't know. I certainly think I'm caring with my clients. My clients are important to me. Defendants, they're not my responsibility. It's different. I don't owe a defendant a duty of loyalty. I don't need to fight and defend a defendant. In fact, I'm the source of their torment. I'm a monster for hire. We all are. All employment attorneys are monsters for hire. But there are many ways hired to torment the defendant until they give our client money. I mean, it's through a case, right? We're bringing a litigation, but mostly defendants view that litigation as a source of torment. I'm not going to betray my client because you want to fake a suicide with me, right? But I digress. And call in the wellness check, as long as it's safe to do so. All right, this is a long video. I hope that I hit the high points of the original video. But this is just a terrible, horrific way to approach employment attorneys. Do not do this. Do not do this. And this video makes one fewer person per year approach me in a fashion that says, I will kill myself if you don't take my case. This video would have already overproduced in spades. Like, I'd be so happy with just one less per year. That would be amazing. And I'm not saying don't call me. Like, listen, I get it. We can have a conversation about it. But don't lead with 45 attorneys turn me down. Great. Good for you. Pretty sure you don't have a claim. Or at least it's not a good one. Or nobody can afford to take it. Or whatever's going on is going on, right? Or you just scream at people too much. Like, that's another one. There's people just call up and start screaming. And they're not going to get past the non-attorneys. Because the non-attorneys, they're super patient. They're going to be like, hey, you're screaming a lot. I can't understand what you're saying. And the person on the other line, the potential client, is You're like, okay, sounds like you may have lost your job. I would love to try to help you. It seems like you might be upset right now. Would you like to schedule a call, maybe for like tomorrow afternoon, and we could try this again? And if the other person on the line is still just a screaming lunatic, the non-attorney is going to be like, okay, well, my calls are limited to 20 minutes. So I'm really sorry that you couldn't form words and treat me like a human being, but I am going to let you go, right? And then they're going to take that number, and they're going to put it on the do not pick up list, the do not call list, because that person screamed for 20 minutes straight. And there's a good chance you can't help that person. Because if you can't explain your claim, you can't win your claim. You can't tell the story, it's over, morning glory. Alright. Video's too long. If this was helpful, like, subscribe, comment down below. Share our channel so we can grow. Take care, everybody.